Hi everyone, I'm Karen Cole from Legal Minded Friends, and if you're new to my channel, welcome. I'm a UK lawyer. I have been working in the justice system for over 4 decades, and I have worked in the UK court system for 24 years, over 24 years. So my channel will offer you an overview on different aspects of the law. So this is part 2 of our series, Depp versus Heard, case going on in Virginia. And in this video, we're going to cover hearsay evidence in comparison to UK law. So if you're interested in this, stick around for the next part of the video. Thank you. So part 1 covers 2009 to 2012. And in this video, we're going to cover 2013 and 2014. So we're going to do a little bit about what's kind of happening at that time. And then I'm going to kind of put in the UK law, just kind of fit it in. And I've also got 2 sound bites for you that I think you'll be really excited about, because I'm going to introduce you to 2 new channels. Before we take a sneaky peek at the soundbite videos, let me tell you what's happening in Johnny's movie career. As this is a defamation case, it makes sense to have a history of how well he is doing financially. In 2013, Johnny was in the film Transcendence, and that film earned him a cool $20 million. In 2014, after filming Into the Woods, he made a net sum of $15 million and got engaged to Amber in 2014. In November of 2014, Amber alleges that while on a private flight, Johnny physically assaulted her, pushing her into the aisle and kicked her several times in the back. She claims there were witnesses that saw this. There was the flight attendant and Johnny's security crew on the plane. Johnny claims that he could not take Amber's mood, so he went and locked himself in the toilet for the whole flight. Writing statements and giving testimony is evidence, but when claims are made without corroborating evidence, the testimony would be a he said, she said, and it would be down to whoever you believe is more convincing and persuasive. Check out my videos on this subject in the playlist Going to Court. If you're wondering, it's cucumber water. So this is a good time to listen to the soundbite from Nate the lawyer in Texas, as they explain how frustrating the objections are in the United States.
Maybe. All right. So I have a special guest that most people haven't seen before. This is another attorney who's been in the background trying to hide out, but now he's come on the screen. So here he is, John O'Brien, attorney extraordinaire. What's going on?
Hey, Nate, how you doing? Thanks for having me.
I'm doing good. So now you want to jump on with objections, huh? This is your thing, huh?
You know what? It's been driving me nuts the entire time. I've been watching the trial, and it's been crazy.
There's been a lot of crazy objections, but it just is what it is, right? It just is what it is.
Yeah, I mean, whatever the judge says ultimately goes, but I've had some issues with that one as well.
Well, I hope you enjoyed that soundbite from Nate the lawyer. They do a great Q&A and all the different reasons for objecting. So please check out his channel and subscribe if you want to see more of their content. This might surprise some people, but in the UK, we do not stand and say the words objection, hearsay, or whatever. We politely get the judge's attention by raising our hand. So when we don't like what the witness is saying and we're getting the judge's attention, we normally say, this is prejudicial to the case. It's not directly speaking to the matter that we're discussing. So a lot of the reasons are the same. The judge is the one that makes the decision whether or not to allow the witness to keep on speaking. With hearsay evidence, the judge has a lot of power in the UK. So it's virtually the same, like you have to have first-hand information, but some hearsay can be admitted into court if the judge feels that it is relevant to the case and to achieving, a justice. When you're making the statement prior to giving testimony, so that's being the witness, you're giving oral testimony now to go with your witness statement. And in that statement, you've got to provide all the exhibits that you want to rely on for your oral testimony. So if you haven't provided any evidence, then the court's not going to let you keep talking about something that you hadn't mentioned in your statement. So let's say somebody says something on the witness stand that they did not put in their statement, then that might be something to question. Why are we talking about that? That's not relevant. It's never been mentioned. Let's say you've written a statement and you've exhibited what you want to talk about. So let's say you say, well, I made a report to the police, but then you want to rely on that report. The court may want to have the police officer there for a testimony to find out what's happening. So you wouldn't be able to rely on just the police report unless the police report speaks exactly to the matter. So the judge might allow it in or the judge might not. It depends on how much weight the court gives it. You could also have a situation of hearsay if your statement says somebody else said something and then that so-and-so says, yes, they write a statement and they give their account. But let's say that person doesn't show up to court. Then we would ask the court to disregard that statement. And again, the court could, depending on how much weight, but when you're dealing with a judge, it's fine. But I always wonder when I don't work on cases with juries, but I can imagine if you've got a jury, then once something's been, let's say, heard, it's kind of hard to unhear it. So let me give you a little example where some hearsay would be accepted in the courts. If, let's say, there was an email that was from, it is a work email that other people got. So that might be acceptable in evidence. Okay, so far, whatever I've been listening to with Amber on the stand, the evidence just doesn't seem to match up with her story. But I don't want to disregard, that she could be a victim. Personally, I think they've got a very toxic relationship. And but anyway, the next soundbite is, I think, really on point to kind of what we're going through nowadays with the Me Too movement and the believe all victims. So listen to that.
You aren't absolutely fawning and 100% boundaryless supportive to all victims at all times. It's victim blaming.
Identity politics.
It is effectively identity politics.
The core of identity politics.
Yes.
So this is another victimhood movement. Victims of narcissistic abuse. Everyone is a victim, was a victim, or will be a victim. And his dog, of course. I forgot his dog. There's a sociologist, his name is Campbell, and he said that the vast majority of human history had been spent with a focus on dignity and reputation.
Right.
So all human societies,
Yeah.
all human cultures
Yeah.
have been focused on dignity and reputation. He said, in the past 30 or 40 years, we have undergone a transformation from dignity and reputation to victimhood.
Yeah.
So he says people sacrifice dignity.
Yes.
What do you think? Has society become less dignified and would rather be seen as a victim? Or do you think more people are having the courage to speak out? This soundbite is from a larger discussion that is worth listening to if you want to understand the dynamics that play into a narcissistic and codependent relationship. I have left a link below. I hope to see you in part 3. Please like and share and subscribe free as it helps our channel to grow. Thank you.